Pardon me if I'm looking over in this direction from time to time, but we'll go ahead and start with. And again, Ray, if you'll confirm you're seeing the PowerPoint full screen now. Okay, great. I'm going to try one more time to move it to the other screen. I guess it's just not going to let me do that. All right, so closings 101. First of all, I'd like to kind of let everybody take a moment to look at the right-hand side of the screen share, and you see a graphic from Ganek and a little bit of advertising for us. So we like to brag about, first of all, our knowledgeable staff. We have staff members who have been with the firm for literally decades. Of course, we've got a range, but all of the staff members get a lot of extensive training and working hand in hand with the attorneys. As I mentioned earlier, I've been with the firm since '99. I've actually been practicing law since '95, and specifically in the real estate field since 1997. So I personally have a lot of experience. We have other attorneys in the Midtown office with me, 10, 15, 20 years with the firm as well. And a lot of staff members that we've had working with us for years. So we really pride ourselves on the experience of the firm, both the attorneys and the staff members. And of course, that leads to number 2 in our graphic, smooth closings. That's always our goal. We want to make sure that you, the agents out there who are watching, and maybe we've got a lender or two as well. We want to make sure that the closing goes well for all parties involved. And number 1, that's working with the agents who are placing the closing with us in the first place, with our lender partners, because if we don't have a good loan closing, then we don't have a good closing. And of course, the buyers and sellers. We want to make sure they're having a smooth closing experience. We really always set the goal to get people into the closing room if they're closing in person, and out in an hour if at all possible. And so there's a lot of work that goes into preparing and making sure we're ready to achieve that goal. All right, in the graphic number 3, clear communication. That's another thing I personally pride myself on. Thorough communication via whichever means the person receiving the communication wants to receive it. So some people like email, some people like text messaging, some people prefer the phone. We do all of those. So just to take a moment, we are using a software package. We've branded it because the way we have built out the software, we've really tailored it to how our firm likes to operate. We call it Smart Close. And part of that system, when certain milestones are achieved as we prepare for closing, the agents and the parties to the transaction, buyer or seller, depending on what type of communication we're sending out, get both a text message letting them know they have a new communication, and then they can jump over their email and get even more information there. So if you're an agent and you're out in the field, it's nice to get a text to know that there's something important in your inbox. And then next time you're in the car, you have a chance to pull into a parking space and check your email. You can get even more information in your inbox. So number 4, convenient locations. So we have 11 locations to serve you, and we may have a graphic a little bit later, but I've mentioned a few of the offices, and basically we cover the entire, kind of north metro. Anything above 20, I think we have an office fairly conveniently located for you as we fan out as we head north. So again, we may have a graphic to look at in just a minute. I can't remember if that's built into this particular PowerPoint. And number 5, every closing, a percentage of the closing fees go to one of 5 charities that we let our buyer pick from. That program is called Ganek Gives Back. We began that in, I believe, 2017, and that's been a very popular program. Again, at every closing, the law firm will donate to one of several charities, and we let our buyer select which charity we donate to for their particular transaction. Okay, so on to our next slide. So the next one, and Ray, confirm for me, you're now seeing something called, it's an excerpt from our seller information form. Is that right? Okay, terrific. So when we first open a file, and usually, more often than not, the real estate agent who steered the closing to Ganek is usually the one who will send the contract over to us. And we're always happy to go ahead and open a file based on just a contract. We know that if it's financed, we'll eventually get a title order from a lender. And one of the first things we do is send out a communication letting you know that we received the contract and that we're in the process of opening our file, and sort of introducing the closing coordinator and the attorney who will be working on that transaction, and that there will be additional communications that will be coming to the recipients quickly after opening the file. Part of opening the file is we send out a request to both the buyer and the seller with a request for information form. So the one that I'm showing here on the screen is our seller information form. We also have a buyer form, and primarily on the buyer side, we're trying to figure out who the lender is going to be. Sometimes we have borrowers, buyers who have several different lenders that they've been in communication with. There may be one or more of them written into the financing contingency in the contract, but that doesn't necessarily let us know who the ultimate lender will be. So in our buyer form, that's mainly the reason we're trying to capture that information. If we don't already have a title request from the lender, we want to make sure that we reach out and request one. That'll be important once our title work comes in. But we're going to focus today on the seller information form. So the first question we ask, is this your primary residence? And why is that important? Because if the seller is not selling their primary residence, and if they are not a resident of Georgia, then there are some tax implications that we'll need to sort of figure out the answers to ahead of the closing. So our first question, is this your primary residence? If the answer is yes, then we know that we're in good shape, because there's a type of exemption that applies for sellers who are selling a Georgia property where it's their primary residence. So if we have yes, we're good. If the answer is no, the next question we want to, was the property your primary residence for at least 2 of the past 5 years? And that's another type of exemption. So the definition of primary residence is current, or if it was your primary residence, any 2 of the last 5 years. So let's say our seller has moved to Florida and rented their condo in Atlanta for a year. But before that, it was their primary residence for the 4 years that preceded the closing. Then we could still consider it their primary residence, and we will not have to withhold for the Georgia Department of Revenue. So there's another question that's going to come a little bit later, so we'll return to that discussion in just a moment. What type of property is this? We have 3 choices: residential, commercial, vacant lot. Obviously, that a vacant lot could be in a residential subdivision or a vacant lot in a zone area that's zoned commercial. So it's possible you might have to answer 2 of these questions, but vacant lots, the type of title insurance that we have available to us is different. So the vast majority of our closings at Ganek are residential in nature. There are a number of, myself included, who conduct commercial closings as well. But the sooner we know about things related to the closing, the sooner that we can steer that transaction in the right way and ask the right questions and hopefully get the right answers. Again, the goal always being a smooth closing, a timely closing for all parties involved. So then the next question is, we want the seller to provide their principal or forwarding address. Obviously, we would like all of our documents, as we move towards closing, to be accurate, and having a good forwarding address for the seller is very important to us and to, obviously, other parties to the transaction as well. The next question is, title is held in the name of an individual or an organization estate. Now, why would that be important? If you're an individual, then we're going to just need your social security number and your forwarding address. But if you are an organization or a type of estate, we're going to have a lot more questions for you. So that's actually our next slide. So seller number 1, we would ask, first name, middle name, last name, social, email address. our smart close system works best if we have both an email address and a cell phone number for our parties. So if we have both of those, then you'll be getting the text message updates and the email updates. So we, are trying to communicate with you in as many different ways as might prove helpful. So ideally, we get both of those pieces of information, and then we have at the bottom of seller one, is there a second seller? Yes or no? So if there is a second seller, then we obviously need to capture their information as well. And again, it goes to making sure that our documents are accurate. If we have seller one, seller two who are married, then really information that we get from one of them might be sufficient for the purposes of closing. Married persons filing jointly. But a lot of this has to do with how we report the transaction, both in terms of State of Georgia Department of Revenue and also to the IRS. So if we have seller one and seller two and they are some other type of relationship, let's say they are a father and a daughter, then how we report the sale of that property could be very different. For example, the father may have co-signed for the daughter when she bought the property, but it's really been her property with her down payment. She was the one making the payments on the mortgage. So the proceeds would probably end up going to the daughter. So that would be something we would want to try and capture at some point, that the father who's listed as seller one, probably because he was maybe the first one that appears in the title to the property, his interest in the property might ultimately turn out to be 0, whereas the daughter's interest might be 100%. So the sooner we can kind of start to figure out that, the better. All right, so our next slide, organizations and estates. Name of organization. So what type of organizations do we have? Most commonly, we have LLCs, limited liability companies. So with a LLC, we're going to need some additional information. The next, probably most common form of entity that we have is a corporation. Similarly, we'll need some additional documents from the corporation. So we would need first the name of the organization, and then below that we say, please identify name and position, member, manager, trustee, general partner, president, executor, other of the person signing on behalf of the seller. So we're not going to be able to just rely on how the contract signature block was set up. In fact, I have some examples for you which show that unfortunately often the contract is executed incorrectly or incompletely. So we're going to make sure that we get to the right person who has, ultimately what I'm looking for is, do they have the authority to, in this case, sell the property? So if we can get some names and titles here, that's helpful. Unfortunately, we often get back this form where it's filled out, but not completely, not every question answered. But at least, we want sellers to at least give us some of the basic information, and then we'll drill down a little bit further and get the rest of the information that we're looking for. There's also a note a little bit further down. Please note, if the seller is a sole member LLC that has not elected to be treated as a disregarded entity, we will need the sole member's social security number here. That's pretty confusing, probably for most of the people in the audience, our agents. This is a lot of like tax kind of speak, and more savvy sellers know the answers to these questions, but a lot of times even sellers don't know the answers. So again, if we can get the beginning of the answer here, we'll ask follow-up questions and hopefully get ultimately to the right information for closing. All right, the next slide, we talk about estates. So an estate would be someone who owned the property has died, and you'll see our questions here. Please provide the name of the deceased title holder. So we often get contracts that are written in the name of the deceased person, or more commonly, we get contracts over where the executor is the person whose name is typed on the contract as the seller, but that person's title is not included. So we may have property that was owned by Sam Smith, and yet our contract was signed by Sue Smith with no title. So we're going to open up our file, and we're going to assume that we're dealing with Sue Smith as our seller. And so we'll order title from our examiner, showing that Sue Smith is the owner, and our examiner is going to go to the courthouse online first, and then ultimately they may have to also make a trip in person to the courthouse to look for a deed where Sue Smith is the owner. And they're going to have trouble finding that deed because Sue is the owner only by virtue of the fact that she has hopefully been appointed as the executor of her dad's estate. But how are we going to figure that out? We're also going to have to go, the examiner will have to go to the probate records of the county in which the property is located. That would be where we would start first, and may or may not find what's issued by the probate court is called letters testamentary. And that would be something that would appoint, in my example, Sue Smith as the executor of Sam Smith's estate. But what happens if Sam died a resident of DeKalb County, but the property is located in Fulton? Well, then our examiner is going to have to make a trip to two different courthouses. First, they would search the title records in Fulton County where the property is located. And if we have a correct answer to our second question, in what county is the probate recorded? In this case, we'd have a contract that describes Fulton County property. If the question here is answered correctly, in what county is probate recorded? In my example, that's DeKalb. Then we would know right off the bat that our examiner is going to have to make trips to two different county courthouses in order to complete the title. So the sooner we know that, the better, so that our examiner, we don't lose days. What often happens is the title comes back from the examiner and it says, Sue Smith not found as record owner of the property. You can often figure that out because they'll start with the parcel identification number, the tax parcel number. They'll see that the taxes were last issued in the name of Sam Smith, and they'll just let us know Sue Smith's not the owner, Sam Smith's the owner, and kind of go ahead and run the report that way. If we've gotten our seller information form back, then we know, oh, all right, so it's Sue is acting as the executor of her dad's estate, and her dad's estate was probated in DeKalb County. So then we can communicate to our title examiner, hey, I know you guys are running this in Fulton, but we're actually going to need you to go to DeKalb as well. So if we can do that within a day or two of ordering title, that's great, because then we're not going to get a report back from the examiner that is incomplete. We won't have to make them send a report and then a week later go back to a different courthouse, then update the report, send us a new report, new title commitment that has to go out to the lender. So it just becomes a smoother pre-closing process if we know this information up front. So the next question on my slide, prior to submitting this form, you will be asked to upload your authority document. So there's that word again, authority. So we're always trying to figure out who has the right or the authority to sit at my closing table and sign the limited warranty deed to convey title to the buyer. So in this case, what are the authority documents? Letters testamentary, that's if there was a will and if the will has been probated. The next thing would be the will, and then the next thing would be a death certificate if one title holder is deceased and there is no probate. So let's kind of go through this one by one. Letters testamentary, I've already mentioned that it means we had a will, the will has been probated, and the probate court has issued this document called letters testamentary. There would also be an order issued by the probate court admitting the will to probate. So we can ultimately get the will from our examiner, but again, we're trying to get help from our sellers on the front end and we're looking at our real estate agents to help us get that information from the sellers. So the sooner we have information, the sooner we can read the document, the sooner we can evaluate if we're going to have what we need to get to the closing table. Death certificate. So let's say that in our case, the listing was Sam and Sally Smith are listed as the sellers. Sam has passed away, and Sally was his wife, and she's still living. If the two of them held title as joint tenants with the right of survivorship, and that's something we'll be able to look at the last deed and the chain of title and know the answer to that question, that language would appear there, then we don't need probate. All we need is a copy of the death certificate. We'll record that, and that's kind of notice to the world that Sam has passed and that the other joint tenant, in my example, Sally, that she now has the authority to convey title, because as soon as Sam passed away, Sally became the sole owner of that property. But anybody searching title behind us, if we go to closing and Sally signs our limited warranty deed, and that's all we record, then the next closing attorney or the next title examiner is going to come behind us and they're going to go, well, what happened to Sam? Sam was the owner of the property when Sam and Sally bought it back in 1983, but he didn't sign the deed that Ganek recorded. That's why we're going to record that affidavit with the death certificate attached. That way anybody searching title will know Sam died, Sally became the sole owner because she was a joint tenant with Sam, and that's the reason she's the only one signing the deed. Obviously, dead people can't sign deeds, but we need to document that and let the rest of the world know what we did at closing. All right, so our next one, I've got a few examples here of, these are actual contracts that we received, and I don't think it's a problem sharing this information because ultimately these names became public records. So in our first example, if you look at the seller signature block, you can see that it was DocuSigned, or in this case, authentication, and that our seller was Heather Comer, Executor. So any agent out there who does this on their contract, my applause to you, because you've given us a clue. From the moment we open our file, we're going to know that we're dealing with an estate, and that's because of that magic word executor. So if you look underneath, we've typed how the name ultimately appeared on our documents. So seller was actually Heather Marie Comer as executor of the estate of Judy Marion Peterson, aka Judy M. Peterson, deceased. Wow, isn't that a lot? So in probate court, they like to use first, middle, and last names, both for the executor and for the party who passed away. But in real life, on many deeds that we encounter when we do our title searches, sometimes middle names aren't used at all. Middle initials are used more frequently, but rarely do we have a deed which has all three names. So what we're doing with that AKA is we're sort of tying the probate court documents and our real property documents that are recorded in the real property area of the courthouse. So probate is a whole separate area of the courthouse. So we're kind of marrying those two departments, those two areas of the courthouse together, and showing that on our documents so people can sort of see the relationship. All right, at the bottom of this slide, I've got another example, which was a name very, very tiny typewritten, which when we opened our file was certainly hard for us to read and make sure that we did the data entry correctly into our software. But ultimately, that name was Thomas Jefferson Carling Schatzman IV. So let's go back above to the signature block. So someone, and I'm going to, presumably this was the agent, had been dealing, in this case, probably the agent went online and did pull a copy of the most recently filed deed in the chain of title. And they typed Margaret Schatzman, who was the record owner per the tax records, per Georgia Clerks Cooperative, if you have an account and are looking there. In this case, the name of the deceased person was typed in. And then later that was struck through. We're not really sure by who, we didn't ask, but it may have been by Thomas. So he may have struck through Margaret and typed in Thomas Schatzman, executor. So again, at Ganek, when we're opening the file, we had a clue. We got a contract that showed Thomas Schatzman, executor. So we know that we're dealing with an estate. And again, down below, we've typed written in for you just so you can see how it ultimately appeared in our documents. Thomas Jefferson Carling Schatzman. So he had two middle names. The fourth, it's very important if we are dealing with junior, senior, the third, the fourth, the fifth, because we want to make sure that the person that we're interacting with is actually the person who owns the property or has the authority to convey the property. So let's say in this case, instead of Margaret owning the property, the person who died was Thomas Jefferson Carling Schatzman III. If that name had been typed into our contract and that's all we got, again, we're going to send our examiner to the courthouse looking for a deed into Thomas III, when in fact, our person that we're interacting with, who's filling out our seller information form, is Thomas IV, because his dad has died and now Thomas IV is acting as the executor. So the more complete information we get, the better. And that way, again, we're always looking for smooth closings, remember, and we never want to have a surprise at the closing table, obviously. So our smart close system and all the questions that we ask are all designed ultimately to achieve that goal, smooth closings. All right, so let's move on. So corporation, so I'm going to kind of move quickly through this one. A corporate entry, first of all, must be in good standing. So if a corporation was formed and has failed to file their annual return and pay their annual dues, they can be administratively dissolved. Now, that doesn't mean that they can't be reinstated, but that's a process. And there's another way that we can deal with an administratively dissolved corporation if they are in the process of winding down their affairs. That's something else that is allowed. But we're going to modify the deed that we have the seller sign at closing to include a recital that that's what they're doing, and actually reference a code section of the Georgia Code when we do that. So our question right below is, please choose one. So we're looking for, ultimately at closing, if it's a corporation, our person that will attend the closing or sign via mail away, we can have one officer plus a corporate seal, or we're going to have two officers signing our deed. So please choose one. A second officer of the corporation will also sign the closing documents, or number two, I will bring a corporate seal to closing. And then below that, we've got, prior to submitting this form, you will be asked to upload, here's that magic word again, authority documents. Please gather the following to upload on the last page before submission. We ask our parties to initial that block. So one, proof of good standing. If our seller doesn't provide that, we'll go online. If our corporation was formed in the state of Georgia, then we're gonna go to the Georgia Secretary of State's website, and we can look to see, are they in good standing? Have they paid their annual dues? Terrific. All right, so number one down. Articles of incorporation. Those are also a public record, also available on the Georgia Secretary of State's website. So we can pull those as well. But things that are not public records, corporate bylaws and any amendments thereto. And then number four, ultimately, we're going to ask our corporate seller to please provide a corporate resolution authorizing the sale of the property on the terms that are named in the contract, and telling us who will be signing at closing. So we can sometimes have, we look at the Secretary of State for a corporation, it will tell us the CEO, CFO, and the secretary, and that may be three different persons. So again, we need to know which of those three persons are coming to closing, and it may turn out to be none of them. It may be some other officer who is appointed for the purposes of our sale, and our resolution is going to tell us that. So again, the main purpose of all of this is the sooner we start asking the questions, the sooner we get the answers, the sooner that we at Ganek can make sure that we are preparing our file correctly and asking additional follow-up questions that we may need to know the answers to. All right, so here's an example of a signature block where we got the contract and it was signed by Rachel Vilcius. So we would open our file with Rachel Vilcius individually as the seller. We would order title that way. And again, our examiner is going to be confused because Rachel is not the owner of the property. Underneath the signature blocks, you can see where we've typed in actual seller turned out to be OnWin Inc. The contract was signed by Rachel Vilcius, who, as it ultimately turned out, was the secretary of the corporation. At closing, if we were told that OnWin Incorporated does not have a corporate seal, then I would probably be expecting both the president, who didn't sign my purchase and sale agreement, and most likely Rachel as the secretary to attend closing or to sign my docs as part of a mail away. So one officer, usually the president, signing, and then the secretary does something called attesting to the president's signature. So you have two officers acting on behalf of the corporation. And again, that's waived if the corporation has a corporate seal. So in this case, I'm going to guess more likely than not, Rachel attended our closing and she signed on behalf of OnWin Inc. And next to her signature, she affixed the corporate seal on behalf of OnWin. So that would be acceptable as well. All right, next slide. A limited liability company. So we see LLCs a lot more frequently now than we do corporations. So let's read through this slide. The LLC must be in good standing. So just like a corporation, the LLC has to be in good standing. Prior to submitting this form, you will be asked to upload your, again, authority documents. So in this case, we're still looking for proof of good standing. And again, if our LLC was formed here in Georgia, that's easy. We'll just go to the Georgia Secretary of State's website and we'll print that document out. That's easy for us to obtain. Let's say instead that our LLC was formed in the state of Delaware. Now that is going to present a problem for us because Delaware is a little more stingy in terms of what they will provide to a party logging into their website. Delaware, you have to pay to get some of the documents. So we would rather not pay and have to charge our seller a fee for something that they could provide to us on their own. So we'll still go to the Secretary of State website for the state of Delaware. We'll still look to make sure that the name appears and it matches our contract, how the name appears on the contract, how the name appears on the last deed in the chain of title. We'll look to see that they exist. But in terms of their articles of organization, would rather not have to pay for that. For Georgia, we can print those out for free. So with a corporation, we want to look at the articles of incorporation. For an LLC, we're looking for the articles of organization. So an LLC is organized, a corporation is incorporated, two different terms. And then the third thing, just like the bylaws for a corporation are not a public record, the operating agreement for an LLC is also not a public record. And operating agreements in Georgia, sometimes an LLC is formed and they never adopt an operating agreement. We need to know that. If they do adopt an operating agreement, it could literally be 1 page long. It could also be 100 pages long. So the sooner we get that document, the sooner one of our attorneys can review it. And just to mention, something that's different about Ganek, some of our competitors, they let the staff members do all the work. And if they're really well trained, that may be fine. But the policy at Ganek is attorneys are the ones to give the final review of the title report that comes over from the examiner. Sometimes we have multiple versions, revisions to that report, updates to that report. Each time an update comes in, it gets reviewed by an attorney. And the same thing goes for authority documents. Those documents get reviewed by an attorney, and we make notes for our staff members so that they know, how to set up the signature lines in our software, and when they produce documents, so that we know that those documents are properly produced and will be executed correctly. And then here we use the term a resolution approving the transaction. With LLCs, those resolutions are often called consents. The officers for an LLC are different. You have to have a member or maybe multiple members. Sometimes an LLC has a manager, sometimes it doesn't. Sometimes it has more than one manager. So reviewing the operating agreement hopefully will answer all of those questions. Now, I will also mention there's a lot of really poorly drafted operating agreements out there. So sometimes we have to sort of kind of use our best guess as to what the intention was. And sometimes we'll even go to one of our title insurance company underwriters and ask for a second opinion and get their approval to rely on that document. So here's an example of a contract that we received, and it was, the signature block was filled out properly, Mike's Properties, LLC. And unfortunately, .loop, and I'll admit there's so many software packages out there. I'm not the person who sets up signature lines, so there may be a way in .loop to do this. But really, the person, the human being, what we call a natural person signing our contract, in this case, I should have seen a signature from Richard M. Rogers. But we have Mike's Properties LLC, .loop verified. Well, an LLC can't sign its name. So not properly documented, but ultimately we got there by reviewing the authority documents. We came to the conclusion that the seller was, as listed here, the typewritten underneath the signature line, Mike's Properties LLC. That part was correct. But what should have been above the signature line is Richard M. Rogers as managing member. So in this case, the LLC doesn't have a manager. The member does the managing. So we use the title managing member. Trust is another way of holding title. So again, the magic word, authority document, or magic words, authority documents. We're looking for either a copy of the trust agreement, not a public record, or something called a certificate of trust, which is often prepared by an attorney, which is sort of a summary of the most important terms that we have in the trust agreement. If the owner if the trustee doesn't want to share all of the terms that are found in the trust agreement, then a certificate of trust is usually acceptable. All right. So here's an example of another contract where the name of the seller was typed in underneath the signature line as Frederick Goldberg. And someone, again, was smart enough to amend by typing in this additional language above the signature line. So it was signed by Frederick Goldberg, but someone added the title, signing individually and as trustee of the Goldberg Family Trust. So once we got the trust agreement, you can see underneath where we typed in, here's how our documents ultimately were prepared. Sellers were Frederick Goldberg and P. Joyce Goldberg as co-trustees of the Goldberg Family Trust, dated March 30th, 2017. So in this case, Frederick signing the contract by himself, he really didn't have the authority to do that. But ultimately, once we got to closing, we had both Frederick or Fred and Joyce sign our limited warranty deed. So we know that they conveyed good title to our buyer. Partnership, another type of arrangement that you can have. We're looking for a copy of the partnership agreement. Again, the agreement itself is not going to be a public record. we'll be able to verify the partnership has been registered with the Secretary of State, but that partnership agreement, you know, typically, I mean, 99% of the time would not be a public record. So here is an example of a contract that we got with a handwritten signature, nothing typed under the print or type name. And as you can see down below, the buyer was in fact Van Daniken Shaw. So that was fine. Seller turned out to be North Georgia Growth Fund, Roman numeral 2, comma LP, which is a limited partnership. Note how we were provided with neither the name of the LP nor even the name of the person signing. We were also provided with zero contact information for either the buyer or the seller. This makes our job kind of difficult, doesn't it? And then you can see further down what the signature block on the limited warranty ultimately looked like. So it was North Georgia Growth Fund, Roman numeral 2, LP, by a different LLC, its general partner, by another LLC as member of the LLC just above it, by W.L. Norton Agency, Inc. So we're dealing with a limited partnership, 2 LLCs, and a corporation before we finally get to an individual, Frank K. Norton Jr., who had the authority to sign for the corporation. So we had to review 4 sets of authority documents to make sure that Frank had what? The authority to sign our deed, and that we were conveying good, marketable, insurable title to our buyer. Here's another example. We just got a couple individual names down below. This one isn't much better. The buyer was in fact Renee Levon Washington II. Sorry, that was the buyer. We at least got his phone number. Seller turned out to be Heath and Roden Holdings LLLP. That's a limited liability, limited partnership. So yet another form of entity that is authorized under Georgia law, much less common. The authority document they provided was an operating agreement, which is something that you would expect to receive from an LLC, not an LLLP. For an LLLP, it's ultimately what? A limited partnership. So I'd be looking for a limited liability, limited partnership agreement, but that's not what we got. We got a document that we would expect to receive from an LLC, a limited liability company. Here's what it looks like on the Secretary of State's website. So we were able to confirm that it existed. There's a certificate of limited partnership. We know that it was formed in Georgia, December 20th, 2018. Here's some more information. So we do get some names of general partners: Matthew Van Roden, Jonathan Von Ryan John Heath, both named as general partners. We were ultimately able to get an underwriter at Chicago Title to allow us to insure title, despite the fact that the authority document was the wrong type of document. And this is a quote from the underwriter. Since the state has them registered as an LLLP, I think that is what they are, in spite of what the operating agreement states. So yeah, we kind of had figured that part out on our own. He writes, you could squint really hard, and call the operating agreement their partnership agreement. So I think as long as the 2 partners / members, so they're named as general partners with the Secretary of State, they were named as members in their LLC, their operating agreement. So he kind of uses a / sort of marry those 2 titles together, that they would be entitled to execute the documents as the sole partners, and Chicago Title was willing to, they were also administratively dissolved. So we had to deal with that issue as well. And this was considered part of the winding up of the company's affairs, which I mentioned earlier. All right, so we've got about 12 minutes left. So let's talk about special circumstances and HOA information. So all of these questions are very important too, because these are also things that could keep our closing from staying on track and could slow down, delay our closing, We never want to be, Ganek never wants to be the reason that a closing gets delayed. If other parties, if that's, if another party makes that happen, then that's on them. But we at Ganek, if you've got a closing date, we want to honor it, and we're going to make every effort to make sure that it closes on time and again closes smoothly. So one question, are all sellers US residents or US resident aliens? The reason that's important is if the answer to that question is no, then we may have to withhold for the IRS. And that's going to be a lot of money. Withholding for the IRS is not withholding on the gain from the sale. It's withholding based on the sales price. And what's really, really weird is that the obligation to withhold part of the proceeds from the closing is on the buyer. And most agents and most buyers and sellers aren't aware of this. The law firm, we know how it works, and our job is to educate our parties to our transactions and to help them hopefully provide the right answers to us. If the answer to that question is no, then there's going to be additional communications that go out from Ganek. The next question, are all sellers US Georgia residents? So I mentioned that at the very beginning. If you're selling a principal residence, then there's an exemption even if you live out of state, as long as you lived in the property and it was your personal residence for at least 2 of the last 5 years. So if you're a Georgia resident, you can also be exempt. But if you are an out-of-state resident and you are selling a property which was not your principal residence for at least 2 of the last 5 years, then we are potentially going to have to withhold for the state of Georgia as well. And that's a different set of communications that will go out depending on how the answer to this question is sent back to us. So again, trying to educate our sellers as to here's what your withholding is going to look like for the state of Georgia. Next is, will all sellers be present at closing? So if not, how is the closing going to occur? Power of attorney or mail away? Again, knowing the answers to these questions, gives us time to prepare a power of attorney for the seller to go get it executed. It has to be signed in the presence of a witness and a notary public, or for the law firm to prepare a mail away. So that's preparing all the documents ahead of time, making sure that we have a notary set up to assist the seller getting their docs signed. Those docs go out far enough in advance of closing that the seller, even the most disorganized sellers, have enough time to get the docs printed out and go meet their notary to get the document signed, to get the docs sent back to us for review, for then the original docs to be overnighted to us. We make that process very easy as long as the seller follows our instructions. Unfortunately, a lot of sellers don't. And so we end up having problems. So the sooner we get that process started, the better. The next set of questions, divorce still pending or settlement agreement? If a divorce is still active, then we can't close unless the parties enter into a settlement agreement that is accepted by the court, filed with the court, and enough time for an appeal has run. So we're trying to figure out things that could ultimately delay our closing. The sooner we know that there's an active divorce, the better. Same thing goes for a bankruptcy. If that bankruptcy is still active, we're going to have to involve the bankruptcy court. We're going to have to get an order approving the sale of the property. If the seller is doing something called a 1031 exchange, where they are selling an investment property, selling one investment property, buying another, we have to interface with the exchange company, what's called the intermediary, and the intermediary will have their own set of closing instructions for us that we have to adhere to. So the sooner we know, the better. Same thing goes with a corporate relocation company and mobile homes. We don't, fortunately, and at least in my Midtown office, we don't close a lot or very rarely a mobile home. But it depends on if the mobile home has been affixed to the property, then it's considered the equivalent of real estate. Or if it's not affixed, then it's really treated more like an automobile. So that can be important to our transaction. So here's some examples of some of the communications that we send out that are through our smart close system. So if the seller information form comes back and we're told that they're not a Georgia resident, they are not selling their principal residence, then we're going to educate them about what is non-resident withholding. So this communication, this is what it looks like. And again, closing coordinator and assigned attorney, we send them the affidavit that they'll need to sign at closing. We send them the Georgia's Department of Revenue guide to withholding so that they know how to answer some of the questions. For FERPTA, that's where we have withholding for the IRS. We direct them to the seller to the IRS's website for more information. We encourage the seller to consult their tax professional. We also have a service that we have a relationship, an ongoing relationship with, that can provide some guidance to sellers. They're called FERPTA Solutions. They're just a referral. We don't recommend them, but they do assist sellers. That's the purpose of their business. Seller power of attorney. If we're dealing with individuals, then a power of attorney is appropriate. But if our seller is an LLC or a corporation or some other form of entity, a power of attorney may not be the correct solution to that problem. And also, we're going to make sure that our power of attorney is properly executed. We want to, ideally, it needs to be executed contemporaneously with our transaction. So, we prepare those, we email them out. We'll sometimes accept powers of attorney prepared by a third party, but we need to review it in advance. Some other questions: is there a homeowners condo association? If so, then we're going to need to get a clearance letter, and those need to be ordered sometimes well in advance, especially if we want to avoid paying what the management companies call a rush fee. A rush fee sometimes means if you need it in something less than 7 business days, then you have to pay a rush fee. Well, that's can be a inordinately long period of time when you're considering, your deadlines to getting ready for closing. So the sooner we have that information, then the more accurate our preliminary settlement statement can be. We also need, if most sellers have a payoff that we need to order. Many lenders require us to have, we have to have the authority to order the payoff, and that's given by the seller. And oftentimes we have to have a signature. Some lenders will accept an electronic signatures, others will not. If you go beyond the mortgage 1, mortgage 2, we can sometimes have other types of payoffs, federal tax liens, state tax executions, judgment liens. So we want to know who's the holder of the lien, and we want to get similarly the authority of our seller to order their payoff, so that again we can have an accurate settlement statement. A proceeds disclosure: if the seller is an LLC and they want us to disperse the proceeds to an individual, we won't be able to do that, because what if that LLC has 3 owners and the person that we're dealing with purports to be the sole owner of the company? We could disperse money to them individually, and the 2 partners wouldn't get their fair share. So we can't take that risk, and worry about one of those other business partners coming back later, not just suing the law firm, but suing our buyer, suing, they'll name anybody they can think of as a defendant in that lawsuit. So it's not just protecting the law firm, it's not just protecting the title insurance company, it's protecting the parties to our transaction. All right, I thought we had this slide. So here's some of the locations for Ganek. So earlier this year, I'm looking at the left-hand side, we moved our Midtown and our Ponce Highland locations. Midtown, we had been over on the west side of 14th Street for 18 years. We moved back over to the original Midtown. We're actually just across the street and a couple doors down from Colony Square, right there at the intersection of Peachtree and 14th. Another very convenient location for you, easily accessed, great parking deck, very wide parking spaces, areas to maneuver your car. So everybody has been really pleased with the parking, and of course, Ganek, we validate. We also moved our Ponce Highland office just a couple doors down to our previous location. We also opened a new office. Well, what we did is we merged with another law firm, Blue Ink Title, managing attorney Marnoush Sadat. Many of you out there may know her. So she merged Blue Ink with Ganek, and we announced it in March, and we're officially merged as of April of this year. We also moved our Kennesaw location. We had a space inside a Regis facility for many years, but now we have our own, Ganek leased location in Kennesaw. I've closed a number of transactions out there over the course of this year. And then over on the right-hand side, you see the map with all the closing locations. Our thought is, as Atlanta grows, we want to grow with the needs of our real estate agent clients. And so we've tried to have lots of different offices to make closing easy for you. If you place an order with us, we will ask, you can order title on our website. And one of the questions we're going to ask is, in which office would you like to close? And which attorney would you like to close with? I can say that I have closed a transaction in every single one of these offices that you see in the map, but for Brazelton. We added Brazelton, I guess that was last year, and I have not made the trek out to Brazelton yet. I would probably just assign that closing or transfer that closing to one of the attorneys in our Gwinnett location. Let's see if we have anything else. All right, so there's some of the contact information for us. So again, want to thank everybody for joining us today. And Ray, thanks for providing the introduction. Did we have any questions in the chat?
We didn't have any questions, but I wanted to share with you that this was an amazing, if anything, explanation about the closing process and how agents can use this like information as a tutorial almost. It was a lot that I learned here today. So I appreciate your time. Thank you, Mark. The experience.
All right. Well, thank you, everybody. And thanks, Ray. It was my pleasure to host today. All right. Have a great rest of your day.